We do intend to spend the first 5 minutes to continue our discussion on adjudication. We had requests for the floor from Canada and CCPIT. If the delegation is still willing to speak, please can you raise your hand so that we can give you the floor?
So, very good. I have first in line, and please remind that we have 5 minutes for all three speakers because the next session needs to start. So we have first Fika.
Yes, hello. Yes, thank you for giving us the floor, Fika. So just to indicate, Forum for International Conciliation and Arbitration. FICA is a non-governmental group of practitioners with experience in the field of arbitration, mediation, and other forms of alternative dispute resolution, originating from different legal systems in the world. It has among its members a number of practitioners, both from civil law and from common law jurisdictions, with experience in adjudication, in particular in the international construction sector. Given the current state of national laws on adjudication, whereby there are laws on adjudication in some jurisdictions but not in others, and given the disparity between existing laws, FICA wishes to give its support for a further examination of adjudication in UNCITRAL Working Group 2. FICA would welcome it if a model law on international commercial adjudication could be developed as a vehicle for harmonization and improvement in view of the flexibility it would give to states in preparing new adjudication laws. This model law could be developed in advance of any convention on international commercial adjudication. The FICA task force has already made some preparatory work with respect to a model law dealing with different aspects of adjudication, including the enforcement and the challenge of adjudicators' decisions. FICA will be happy to share this with the members of the working group if the working group will further examine the subject of adjudication. Thank you. This concludes our presentation.
Thank you very much. And I have, last but not least, Canada. You have the floor.
Thank you. Thank you to our moderator and to all these speakers, and also to those that have shared their additional experience with adjudication or with exploring the topic. There's been quite a rise in interest on this topic across Canada by many of our 14 jurisdictions, and that's why we thought it is an interesting topic to look at. We feel internationally a project on adjudication may help fill a gap and bring a solution to a cross-border problem. We see that there are very clear benefits, as we heard today, to adjudication. And if any of you would like additional information on some projects in Canada, you can reach out to myself, Alan, or Pierre. Thank you.
Thank you very much indeed. And with this, I would like to conclude the session on adjudication, and we'll give the floor to Jay.
Great, thank you. So we'll now begin our session 6, which is on technology-related disputes. When the Commission requested the Secretariat to conduct this colloquium, one of the agenda items that was specifically mentioned was that, among others, model provisions that could be utilized in the context of technology-related disputes or provisions to be incorporated by reference in dispute resolution clauses. We'll hear a background from Cedric as we continue this, but this was based on a proposal from Japan and Israel as part of your future work. And in last year, the Commission requested that the Secretariat continue to engage with experts with a view to preparing an outline of such provisions to assist in the operation of technology-related disputes. So the document that you have in front of you, which is Working Paper 224, is a first draft prepared by experts to facilitate the discussions on technology-related dispute resolutions. It is not a text by the Secretariat. It is a mere first draft that was shared and prepared by the experts, and we have presented it to stimulate the discussion in the working group. We have a few speakers to kick off the discussions. We'll first give the floor to Cedric from Israel to give us a little bit of a background of how we came about this project. Cedric, you have the floor.
Hi, thank you so much, Jay. First and foremost, we'd like to thank the Secretariat for allocating the resources required to develop this proposal, which was originally submitted by Israel and Japan. We also express our heartfelt appreciation to the group of experts for drafting a detailed and thorough draft, which provides an excellent basis for discussions and a launchpad for the project. When we started our initial research on the subject, we consulted with in-house counsel, lawyers from private firms, and VC funds, and they all told us the same thing. The high-tech sector is underusing alternative dispute resolution mechanisms because these mechanisms are not tailored to their needs. And the more we broadened our consultations, the more we felt that this feeling is shared by high-tech companies in different countries. Just recently, during Tel Aviv Arbitration Week, in a panel with the Deputy Attorney General for International Law in the Ministry of Justice and the President of the ICC Court of Arbitration, representatives of the private sector and arbitration fields noted that the lack of tailored dispute resolution mechanisms to resolve technology-related disputes is a matter of concern. The high-tech sector presents some unique characteristics. It's highly technical and specialized, dynamic, and populated by micro, small, and medium-sized businesses. It also requires different procedural elements from existing traditional dispute resolution mechanisms, very short timeframes, expert neutrals, flexibility in the process. And there's a fairly wide gap between these requirements and existing arbitration rules. So we see future arbitration provisions tailored to the technology disputes as filling this gap. Future work by UNCITRAL in this field is not just about helping one industry. The high-tech sector cuts across industries because today technology is embedded everywhere. It's also a matter that transcends large companies. SMEs that are so crucial to economic development everywhere need to have dispute resolution mechanisms that meet their needs. Much thought must still be dedicated to work on this draft, and hopefully this week and in the next couple of years, to ensure that the instrument can be as effective, efficient, and comprehensive as possible. But we think that the basis is there. Down the line, future provisions for high-tech disputes could be included in a short, concise text, which can be referred to by parties either in part or in full, depending on their needs. So we very much look forward to hearing the comments from the working group delegates and other participants on the draft, and hope that at the end of this process, UNCITRAL can be one of the pioneers in creating a supportive environment for the use of dispute resolution mechanisms to promote technological developments. Thank you.
Thank you, Cedric. And before the working group actually jumps into the discussions about the draft provisions in Working Paper 224, we invited Elliot to give us the perspectives of how the tech companies are responding to these new traditional and new ways of resolving disputes. Elliot, if you're online, please can you share with us your experience?
Thank you so much. Good afternoon. My name is Elliot Friedman. I'm a partner at Freshfields in New York, specializing in international arbitration. It is an honor to be part of this session. Thank you so much for having me. I have, as was just noted, been asked to give the perspective of tech companies on traditional and new ways of resolving the disputes they face, and I have been given 8 minutes to tackle that momentous task. So I will start with a health warning. I speak from my experience, and my experience is necessarily limited. I practice in New York, and my clients tend to be large, established North American tech companies. The disputes I see tend to be business-to-business disputes, not business-to-consumer disputes. So that is the rather narrow perspective from which I start, and I know that it is of limited use given that you are looking at rules for all different types of tech disputes. including those that need to be resolved quickly, those that are low value, and those that involve consumers. So with that warning about my fairly narrow focus, let me begin. I think we can take it as a given that we are going to see a significant uptick in tech-related disputes. As tech companies continue to increase their share of world trade, they are more frequently going to find themselves in disputes. Many of those disputes will be international in nature because the market for most tech products and services is about as international as it gets. But that has been true for quite a while already. The tech companies have been huge parts of the world economy for many years. So why haven't we seen more tech companies active in the international arbitration arena? In my experience, the business-to-business contracts entered into by the large US tech companies have tended to provide for disputes to be resolved in the Californian courts, or less frequently in the New York courts. Why has that been the case? My sense is that it relates to bargaining power and familiarity. The established tech companies will often have some degree of leverage in contractual negotiations, and I've seen that leverage used to negotiate for Californian courts clauses really across all manner of international contracts and with counterparties from all over the world. The price of doing business with a US tech major is sometimes submission of disputes to the courts of California, which tend to be the courts that they and their external lawyers are most familiar with. Now, as an international arbitration lawyer, naturally, I think that's not the best outcome for many international contracts. But let me take the other side of the debate for a moment. Let me defend courts clauses for a minute. And in that way, I hope to illuminate some of the impediments that were just mentioned, some of the impediments to the greater uptake of arbitration for tech-related disputes. It's often said, and I've seen it in the draft provisions in Working Paper 224, that the arbitrators in tech-related disputes need to have significant technical expertise, and that arbitration is therefore the better option because you can choose decision makers with that expertise. That's definitely true in some tech-related cases, but I think it's not really true for many others. Most disputes that are resolved in arbitration are contract disputes. And while the subject matter of the contract might be highly technical, the dispute is often not that technical or not so technical that a non-specialist arbitrator, assisted by competent counsel pleading and explaining the details of the case, can't grasp it. So while the ability to choose specialist arbitrators may be a big boon for some tech-related disputes, and I'm sure there are many, I think it's risky to lean too heavily on that advantage because many tech-related disputes can do without it. My second defense of the large US tech companies adopting courts clauses rather than arbitration clauses has to do with dispositive motions. Many cases can be resolved or significantly streamlined through the use of early dismissal or summary judgment style procedures. While the major arbitration rules either provide for or facilitate those kinds of case management techniques, they are not used with much frequency in practice, in my experience. So you sometimes end up having to go through an entire arbitration, including what is often a complex damages phase, for a dispute that ends up being resolved on a jurisdictional point or a narrow issue of contractual interpretation. That is not an efficient way to go about resolving disputes. But on the other hand, these early disposition techniques can be abused by respondents wishing to draw out proceedings. So it is not all one-way traffic here. So those are, in my experience, some of the key reasons why we haven't seen a wholesale uptake of arbitration among the large US tech companies. Now, let me give you two reasons why I think that's a mistake and why the large US tech companies should be looking more closely at arbitration for their large-scale business-to-business disputes. And while international enforceability of arbitration awards is clearly very important, I'd like to focus on two other reasons that receive less attention. The first I can state in one word: depositions. I can think of very few things that are less welcome in the C-suite than depositions of the executive team. They take up time to prepare for, to attend, to debrief. They divert resources and they distract the senior-most executives from their actual job. Depositions, I'm pleased to say, are fairly alien to international arbitration proceedings, and that in itself should be a reason why large tech should think about arbitration more often. The second reason is even more important. It's confidentiality. Most of a court proceeding is open to the public in most jurisdictions. That threat of publicity can be used as a lever of power. If you are worried about preserving the confidentiality of something that is relevant to your dispute, your adversary knows that you are far less likely to litigate. Arbitration takes that risk and the associated point of leverage off the table. If you ask an in-house counsel at a tech company whether they'd prefer to have their disputes resolved confidentially or in the public eye, most will say confidentially most of the time, which should mean that most choose international arbitration most of the time. It hasn't happened yet, but I think it will, which makes the project that this working group has embarked upon even more important. I will finish on that subject of confidentiality with two thoughts on the confidentiality articles in the draft provisions. I see that they wisely deal with both outbound confidentiality in draft provision 6 and inbound confidentiality in draft provision 7. Starting with outbound confidentiality, draft article 6.1 deals with required disclosures as a basis to break confidentiality. Draft article 6.5 then requires the party making that disclosure to give prior notice to the tribunal or the other party. But article 6.5 doesn't then say what's next. What happens after that advance notice is given? Maybe that's intentional, and maybe you've already considered this question, but I can see it leading to disputes. My second thought relates to the inbound confidentiality in draft provision 7. In my experience, this is where the problems really lie. During document production, you're frequently having to hand over highly sensitive documents to a party that could be your most direct competitor. I like how draft article 7.3 allows the tribunal to put in place conditions on disclosure and to regulate who sees certain documents. I would think about adding here an express mention of the concept of attorney's eyes only designations, or to the concept of clean teams, which can be very effective ways to deal with this issue. I have used up my allotted time, so I will stop there. Thank you for your attention, and thank you again for the invitation to speak at this important session.
Thank you, Elliot, for sharing the perspectives of the tech companies and also contributing to the clause on confidentiality we'll get to in session 8, which is tomorrow afternoon. There has already been work done by other organizations in this field, so we would like to hear their experiences first before we jump into the provisions. So first, we will hear from Krenguta and Patricia on the work done by the workforces of the Silicon Valley Arbitration and Mediation Center, which will be followed by presentations by Lawrence Aka on the UK Jurisdictional Task Force, which recently adopted the digital dispute resolution rules. So with that, if Krenguta and Patricia is ready to give us an idea of what's going on in the Silicon Valley Arbitration and Mediation Center, you have the floor. You have 10 minutes together.
Thank you, Jay. Thank you for this invitation that is honoring SVAMC, an organization who started very early in launching 2 groups. I'm chairing one of them and Patricia the other. As far as the group that I'm chairing, it is addressing one specific narrow topic, which in time after our launching has developed much more than we have ever anticipated. Namely, the dispute resolution based on arbitration and mediation for blockchain-based transactions. Now, the blockchain technology has been known as developing different types of business models, particularly platformification, and performing significant changes into the way in which supply chain is used worldwide. Also, intellectual property rights are relying heavily on blockchain nowadays. In this context, the important impact of economical changes brought by the blockchain has led to important developments from legal perspective. We have seen smart contracts, automated enforcement. We have seen NFTs, non-fungible tokens developing, and digital assets specific to the blockchain technology occupying more and more the public attention in the new economy, the digital economy. In this context, the project that was started at SVAMC as an initiative was initially an initiative in order to increase awareness. And that scope was achieved, as far as we are concerned, in the sense that also the international community, but more than that, have been able to understand that there is a need for making concrete steps towards the direction of a dialogue between the industry, building the new framework for smart contracts and non-fungible tokens, and the legal world, the providers for dispute resolution services. Just two elements that were in our program from the very beginning: adopting best practices for arbitration and mediation, and creating bidirectional gateways in the new technology platforms. At least these two elements are continuously on the agenda of these days for many organizations worldwide. We are also happy to see that this very project of UNCITRAL, it's actually a step that we have very much anticipated, and we are grateful for the international community to be receptive to the needs of the industries in this respect, because what we have anticipated and significantly work in the direction of increasing the awareness for such need was to gear a dialogue in order to identify the further measures in consultations with state and international organizations and also businesses worldwide. With that being said, I would only add that we have performed a survey in the course of the last 2 years, namely 2020, 2021. And in that survey, we have tried to measure the status quo, to identify which are actually the type of dispute resolution mechanisms used in this context of the blockchain-based transactions. And our findings at that time was surprising. Namely, many companies were reluctant into conveying the message about what type of dispute resolutions they are using or intending to use, considering it as part of their business advantage, part of their competitive advantage, part of their innovation. So the innovative dispute resolution mechanism, like for instance, crowd justice or similar, were considered as part of their strategy of acquiring a share of the market. And that is a very important development as far as we are concerned, namely dispute resolution clauses as competitive advantage in the business world. The second conclusion, and that will be my last part of contribution to this discussion, is that unfortunately, there is also a wide ignorance, or rather, I would say excessive optimism as to the power of automated contracts, of smart contracts, to remove the need for dispute resolution. So there is a certain number, quite significant, unfortunate, of smart contracts used internationally that are not anticipating in any way the dispute resolution mechanism. They are simply ignoring it, hoping that the code would replace the law. I thank you for your attention, and I'm looking forward to participate in the further works of this colloquium. Thank you.
Thank you. Patricia, can you just continue?
Yes, thank you very much. I hope that you're all able to hear me. I'm getting some unstable internet, so please alert me if it's a problem. As Kraguta said, there are two task forces the Silicon Valley Arbitration and Mediation Center have launched, and I'm co-chairing together with Henriques and Eduardo Henriques and Paul Cohn, the task force on tech and tech companies and their disputes. And so we are not looking at technology and arbitration, but the specific industry and for tech disputes in international arbitration. And we are not looking into mediation, but rather only focused on arbitration. Now, in our task force, we started with a white paper in which we identified what we thought might be some of the particular issues that we should address. And we also tried to venture some particular reasons why the tech industry might be underusing arbitration and ventured to test those during the task force work. So one of the things in the task force, which I think that all of us understand is a bit challenging, is to identify what is a tech dispute. What is a tech company that may have disputes? I mean, certainly today, all kinds of industries have technology in the context of their business, and they may or may not qualify as a tech dispute. Similarly, companies which are tech companies may have a number of disputes that may arise that have nothing to do with their core technology services and products which they're providing. So the definition of what is a tech dispute and what is a tech company is elusive and but it is somewhat key to trying to identify the ways in which we can better serve those disputes and those companies, and indeed identify what kinds of disputes and needs that we're looking at. As has already been well described by the previous speakers, there are a number of needs which are unique to tech companies and to tech disputes, which are currently not being adequately served in making arbitration fully aware as an option with industry in this practice area, as well as serving the particular tool that may be needed. We think that it is absolutely timely and not at all coincidental that there are a number of initiatives besides the Silicon Valley Arbitration and Mediation Center initiative that are operating in this space to try to engage in a dialogue with the users to try to ensure that we can adapt the procedures and adapt the dispute resolution mechanisms, processes, and offerings to better serve the user particular needs. And they can vary. We must keep in mind that we're trying to serve the entire community of business users. Many tech companies may be startups, which require quick resolution and inexpensive resolution because they do not have the capital to engage in financing a long, complicated, inexpensive dispute. Break it for their company. Other tech companies are very large and very well resourced and very well lawyered with expertise who can engage in such disputes. So we really need to work across the spectrum to ensure both small, medium, startup companies can access meaningful dispute resolution mechanisms that can serve their commercial objectives, and while also offering those kinds of solutions which may be better appropriate for complex, large disputes for big players in the market. And quite hopeful that all of us working together are going to be able to achieve that. We look forward to having input and continuing working with all of you, all of the stakeholders, all of the users, all of the experts in this area.
Thank you, Patricia. I think your comments on what is meant by tech disputes, what is a tech company, does it apply to small startups or big tech companies, will actually guide us when we discuss draft provision 1, which provides the scope and the definition of tech-related disputes in the draft provisions. When we were preparing the draft provisions, we also noted that the UK Jurisdictional Task Force had adopted the digital dispute resolution rules, and on that point, I'd like to invite Mr. Lawrence Aka to give us a short overview and some of the peculiarities of the digital dispute resolution rules. Lawrence, you have the floor.
Distinguished representatives, ladies and gentlemen, good evening from England. I'm honoured and very pleased to have been invited to talk to you this afternoon about the UK jurisdiction's Task Force's digital dispute resolution rules. The UKJT, of which I'm a member, is a task force of the government-backed initiative known as LawTech UK, which was established by our Secretary of State for Justice. Its purpose is to enhance the role of technology in legal and court services for the benefit of society and the economy, and to demonstrate that English law and jurisdiction provide a state-of-the-art foundation for the development of distributed ledger technology, smart contracts, and other advanced technologies. You might know that in late 2019, which seems like an eternity ago, the UKJT published a formal legal statement on the status of crypto assets and smart contracts. The aim of that was to give a proper legal foundation to these technologies in the UK. The statement addressed a number of important questions about how crypto assets and smart contracts will be dealt with by English law, and that was very well received within the industry. I'm pleased to say it's now been followed in various court judgments in the UK and elsewhere, and quoted in multiple jurisdictions across the world. For the same reasons that we've heard discussed in relation to the UNCITRAL expedited arbitration procedure, rapid dispute resolution is of central importance to the growing digital economy. The UKJT then took on a further project to address that need. We held extensive public and private consultation with lawyers, technical experts, financial services, and commercial parties. And after that, in April of last year, about a year ago, we published the digital dispute resolution rules. I'm proud to say they've achieved widespread acclaim. They've been described as innovative and groundbreaking. And although their origin was in relation to blockchain and smart contract disputes, they're in fact not only applicable to those disputes, but to all tech disputes, and indeed potentially to all disputes. In the time I have available, I'd just like to outline for you a little of the thought process and the debates we had whilst drafting the rules, and some of their more unusual aspects. And I'm sure that some of these issues are similar to those that the working group has considered. The starting point for us was to consider what form of dispute resolution was more appropriate. We thought about court-based processes, and there were various schemes in the UK for rapid resolution of court cases, but we ultimately settled on arbitration, and that allowed us to fulfill two objectives. First, the flexibility of procedure to meet the needs of the individual case, and secondly, the choice of suitably qualified arbitrators. We were very keen to keep the rules as short and uncomplicated as possible, to encourage their adoption and their comprehension by non-lawyers, particularly technologists. And we hope we've achieved that. There are only 16 rules. You can fit them into a couple of pages of paper, and we've tried to draft them in plain language. That hasn't always been possible, but we've done the best we can. They also come with guidance in the form of frequently asked questions, which are not binding. Now, the issue about the need for the tribunal to understand the technologies involved, or at least to be able to understand the technologies involved, also fed into the appointment process. We did not select institutional arbitration, though there's nothing to stop the parties invoking the assistance of an arbitral institution if they want to. Instead, we've provided for the tribunal to be appointed by an appointment body, the Society for Computers and Law. That is an educational body within the UK, but I would say most technology lawyers are members of it, and certainly it has access to most legal and other professionals in the field. There is no pool of arbitrators as such. The Society has no role after appointment, except that it can publish anonymous statistics And if the parties agree, it may publish anonymized awards. And that deals with another issue that we faced. It is obviously of benefit if there is a body of law which develops concerning new technologies. People can see how matters are dealt with in previous cases. And we considered it important to have awards published if possible. Of course, confidentiality is of utmost importance, and that is maintained. The parties have to consent to publication in an anonymized form. The timetable for submissions is deliberately very short. The initial response to a notice of claim is to be delivered within 3 days. It's not a full claim and defense procedure, but it's intended just to inform the appointment body in the selection of a tribunal. The appointment body has regard to the number of arbitrators requested, but is not bound by what the parties say. We then had to decide what happened after that. A great benefit of arbitration is its flexibility and the ability to tailor the procedure to a particular case. But arbitrators often end up, out of habit, adopting the same or similar procedures each time. And we wanted to encourage them to move away from that. We are fortunate in the UK to have a flexible default arbitration procedure in our Arbitration Act, which gives arbitrators a great deal of discretion, and they are supported where necessary by the courts. So what we've done is to provide for the actual procedure to be very open-ended. We've left in the procedure for the arbitrator and the parties to determine themselves, provided that natural justice is observed. But the rules are nevertheless drafted to encourage very speedy determination and express consideration of the use of technology. And our hope is that it will give arbitrators the confidence to be a little inventive. One important deadline is that the tribunal should use best endeavours to produce an award within 30 days from appointment. That can be departed from if the parties agree. That obviously dictates a speedy procedure overall. And there is no right to no absolute right to an oral hearing. The award can be in electronic form, but it must be signed, and the rules say that that can include by way of digital signature or cryptographic key. There is no appeal to court on questions of law or fact, but there is still the right to challenge what we would call procedural irregularity, but that is fairly tightly circumscribed by law. The tribunal has a discretion over what form the evidence is to be in, but as far as practical, it is to permit, and indeed is encouraged to permit, evidence to be given in electronic form. This is one of the several provisions which in fact does nothing more than English law would allow for anyway, but which has been stated expressly in the rules in order to encourage the parties and the tribunal to think about it. Lastly, I'd just like to mention two of the more innovative aspects of the rules. The first is that there is provision for arbitration to be conducted anonymously or pseudonymously. Obviously, the parties have to be known to the tribunal, and the tribunal has to be alert to money laundering regulations and the potential for abuse. But if the parties have agreed on it, they don't have to provide their identities to each other unless the tribunal thinks it necessary. That supports party autonomy and the needs and interests of participants in a number of cryptocurrency disputes. And secondly, and lastly, the tribunal is expressly given the power to operate, modify, sign or cancel any digital asset relevant to the dispute using a digital signature or a cryptographic key. Exactly how that works in practice, we will need to see. This might result in arbitrators effectively enforcing their own awards on a blockchain. Of course, they will hear submissions from the parties as to what is appropriate. There are matters I haven't touched on, such as consolidation of arbitrations, which might be important where there are multiple parties involved, for example, a dispute with a crypto exchange or in chains of transactions. And there is support in the rules for other forms of dispute resolution, such as automatic dispute resolution, i.e. by computers, and expert determination. But I hope I've given you something of perhaps a rather rushed flavour for how the rules are intended to operate. They are still new, but we are already aware that entities have adopted them, and we look forward to seeing how they develop in practice. Thank you very much.
Thank you, Lawrence. Thank you for sharing us with the experience of the UK Jurisdictional Task Force and some of the peculiarities of the digital dispute resolution rules. So with that, we have gone through the speakers to give us a broad picture of what we mean by technology-related disputes and what we're trying to deal by providing provisions on these disputes. As you see in working paper 224, we have developed and the experts have prepared some provisions which we can work with. So I'll go straight to the first article, which is Article 1, Draft Provision 1, which provides a definition, a very open-ended definition of technology-related disputes. If you heard Cedric speaking, the initial proposal was about high-tech disputes. And of course, we had to understand what high-tech was, what was high-tech, what was low-tech, what do we mean by tech companies, and are we talking about startups? But the definition that we have in Article 1 is a quite broad term to cover all of the technology-related disputes. Now, on this article, we have the two experts that have prepared this draft. So first, I'll give the floor to Shai and then to our chair to present the definitions. And I think that by discussing the definitions, we'll also be able to identify the scope of any future work to be conducted by UNCITRAL and its working group. With that, I'd like to invite Shai to...
Jay?
Yes, Andres.
Sorry, this is Andres. We will do it otherwise. I will make a very brief introduction and then Shai will go through the details.
Yes, you have the floor, Chair.
Thank you. Thank you very much, Jay. As I said, I will briefly mention a few general aspects about the definition that is provided in the draft about technology dispute or technology-related disputes. And then Shai will explain and go through the technical details. The draft provision 1 was first prepared with the understanding that the draft provisions of tech disputes will require parties' consent for its application, or saying differently, considering that they will be opt-in provisions, following the model of the expedited arbitration provisions, in order, and that was done in order to avoid discussions of applicability and leave to the parties the decision when to use them. Second, notwithstanding that the definition as was conceived, let me put it this way, doesn't have a normative function or a function with respect to the applicability of the draft provision, is still very important in order to provide a definition of what technology or technology-related disputes is. For two reasons, I would say at least. First, because the draft provision's aim is to create a specific mechanism for resolving technology-related disputes. So it was considered necessary as a starting point to provide an understanding of the scope and subject matter of the work to be undertaken. The second reason is to provide a framework in which the other draft provisions will operate, facilitating the understanding of the purpose and function of this draft provision, which in our opinion was key for its proper assessment and evaluation in the discussion. So with that, two brief points, and now give the floor to Shai to walk you through the technical aspects of the definition. Thank you very much.
Thank you very much, Andres, and thank you very much, Jay. Just a brief introduction, and I don't know, can you hear me? Because I only see a screen.
Yes.
Can hear you very well.
Wonderful, thank you. So just a brief introduction about myself. My name is Shai Sharvit. I'm a partner at the law firm of Gornitsky in Israel. I specialize in international arbitration, and I am a member of the LCIA Court and the ICC Commission on Arbitration. After moving away from myself into the definition, I think that the definition, as we drafted it, is trying to do two things. First of all, is provide an open-ended definition in the first paragraph, which the parties may use, and this working group may use later on in defining the scope of the work that needs to be taken, but I think more importantly in defining what types of disputes and the characteristics of each dispute that they will want to address. And on that, in the explanatory notes that we attached to the draft provision, we kind of gave different examples on what type of disputes we consider as technology disputes or high-tech or tech disputes, and what are not. And in this framework, and I'm going back just a little bit to what Patricia Shaughnessy said before about the Silicon Valley Arbitration Mediation Center work, we appreciated although the definition of tech companies might be relevant, it is not at utmost important for this definition and for this work. And we, this was our understanding, because even tech companies have non-tech disputes that will not require special rules or special attentions for the resolution. On the other hand, and this goes back to the saying that every company in the world at the moment is using technology, there will be, or there might be, technology dispute that do not involve technology companies, such as even banks and insurance companies and construction companies, which are definitely not technology companies by definition. So with that in mind, we first of all drafted the first paragraph that gives a very general definition, a very open-ended one. And then we moved on because we felt that although this, as Andres mentioned, although this is not a normative definition, we felt that some guidance is needed. And just explaining that in paragraph 2, that technologies dispute may vary in nature and arise or relate to different rights, to different assets, and are very diverse in nature. I think that when we started working on that, and Andres, and in our discussion within the experts group, I think that the US Supreme Court definition of obscenity and pornography came on, because it is very difficult to define what is a technology dispute. But at least for its core disputes, we know it when we see it. And it's sometimes very difficult to explain, but when we see it, we know it's there, and therefore we had to try to define it in such a way that would include all the different examples that we saw. I think that in this definition, we tried to encompass two different sometimes competing issues that have already been discussed here. One is the expertise and the need for an expert resolution in some disputes, and the other one relates to the speedy resolution or expedited resolution of those disputes. And those two different, sometimes conflicting attributes required a delicate balancing, I would say. But that is not part of the definition. But in drafting the definition and in addressing that, we try to address both types of disputes moving forward. The one thing that was challenging, and it was the understanding that although, again, hardcore technology disputes can be easily identified, sometimes they're not that easily identified. And sometimes they hide as a shareholder's dispute, and sometimes they hide as a non-compete dispute. But in essence, they are purely technology. So we tried, again, in this definition to encompass also those disputes that, although they do not relate directly to technology, they indirectly relate to technology, but in their real essence are technology related. I think that can summarize the definition itself. I would just highlight that in the explanatory note, we tried to give specific examples of types of technologies that we believe are or form part of what is now technology dispute. We had heavy deliberations on whether to include those examples in the definition itself, and decided against it because we understand that if these rules will be adopted, whether in their current form or in a different form, the technology that will exist and will be considered as technology disputes when those rules will be adopted or implemented years from now will vary significantly from what they are now. And therefore, we decided not to include those examples in the definition itself and move them to the explanatory note, which can be updated by itself separately from the definition. Thank you.
Thank you, Shai. With that, I would like to open the floor for comments on this definitions or any questions that you might have to the speakers that have spoken just before. So it's not just Shai and Andres who prepared the draft provisions on the definitions, but any of the speakers that spoke on technology-related disputes. Would anybody like to take the floor? I'd like to give the floor first to Switzerland and then France.
Thank you. I just have a question looking at the definition, which relates to legal relationships of or related to the use of emergent and established technologies, and the explanations I received. Can you give me an example of what is not a technology-related dispute? That goes to the authors of the rules or of the definition. Is there anything that is not that does not fall under that definition, especially with the broad explanation that shareholder disputes can be included or everything we heard?
Thank you. We'd like to give the authors some time to respond. So we'll first hear from France, and then I see also hands in the platform. So let's go in that order, please.
Thank you. Well, I'd like to thank the Secretariat and the speakers for their briefings and for this draft, which is interesting in various regards. I would have two questions. One would follow on from Switzerland, namely, this is a very broad definition, so it's difficult to know what it would not cover. And that poses the problem of its link with traditional commercial arbitration. And I think that this is confirmed if you read the following articles that are being proposed. In certain respects, something could be introduced into a model law, but we wonder how specific it is. But then, on the other hand, it's so broad that it seems to cover issues relating to intellectual property, which is a very specific area where a number of countries are very much jealous of their own jurisdictional power here. They feel that in certain areas their judges have exclusive competence to rule on those matters. So how would this arbitration fit in with this very guarded nature that certain states have with regard to their jurisdictional power over intellectual property? And then a related question, is this developed with WIPO? Perhaps since we're talking about intellectual property, is WIPO part of the experts, or which experts participated in preparing this draft? Was WIPO involved? Those are the kinds of questions that are raised in my mind with this very interesting definition. But I think the definition does throw up a number of questions. Thank you.
Thank you. The Secretariat also has some responses, but we'll go through the list and then also provide our responses as well. We have a request from Israel on the platform. Cedric, please.
Yes, hi. So first, just a general comment on the drafting, and then I'll try to address some of the comments that have been raised, at least from Israel's perspective. In paragraph 2, because it's a non-exhaustive list, so we suggest maybe after the words where it says out of, we would include the words inter alia. Also, the list could include claims of infringement and not just ownership rights. Also, questions of implementation, because a frequently recurring example of tech disputes involves cases of faulty or delayed or buggy implementation and deployment of vendor software into the customer systems. In response to the questions raised by the distinguished delegates from Switzerland and France, we grappled with this very same question at the outset. And while we don't have a definitive answer, our initial response would be that the definition, in our view, should be tailored or should be should track those types of disputes for which a special response is needed, for which a special set of rules is needed. So clearly, we would prefer a definition that is not so wide as to encompass potentially every kind of dispute, but rather the disputes for which technical expertise is required, the disputes for which speed is required, and the disputes for which confidentiality and access to evidence and case management is particularly acute. So whether the current definition as proposed as in the current draft is adequate, we could discuss it, and we could think about shrinking it a little bit or tweaking it to better reflect those disputes. And lastly, we would note regarding the inclusion of IP that in Israel and Japan's initial proposal, we had proposed to exclude it, not specifically because of the territorial nature of IP, but rather because WIPO already has arbitration rules. So there, it's not so much that states are so cautious about wanting to keep IP disputes, but rather because there's already a text which purportedly addresses international IP disputes. However, we would be open to potentially engaging with WIPO and seeing whether there's room for collaboration on this issue. Thank you.
Thank you. Next on the list is the representative from China.
Thank you, Jay. Regarding draft provision 1, the definition of technology, like the previous speakers, we think the definition is too broad. We wonder whether we can specifically define the technology-related dispute and what does it mean and what is the scope of it. On the other hand, we need to consider that in different legal systems, what is the scope of the cases that can be subject to arbitration in China? For example, there are disputes regarding IP, and they are within the scope of administrative disputes, and they cannot be subject to arbitration. Thank you.
Yes, we do also have to think about arbitrability. There's a hand from the public, Mr. Leon. You have the floor. Please be concise in your intervention, please. Yes, please go ahead.
Yes. I would like to say about the mediation and information communication technology, because we are doing that. And I think that we have to talk about that. You're putting a lot of things in this paper in the item 1 and 2, but about the contracts between the developers and the enterprise, that you put a lot of things that are, how I said, too technical. And we're talking about legal design too, because when you develop something like ODR, do you have to have a legal design to develop that, and to have a technology to do a mediation or arbitration, because the most of the time you can't do a mediation or arbitration in a Zoom. You have to have real technology to do that, to have confidentiality inside the technology, to guarantee that.
Thank you.
So
I think
that's my question.
Thank you. I think the use of technology in mediation arbitrations we have discussed during the past 2 days. I think today we're talking a little bit different on how to resolve technology disputes. So I would like to then give the floor to Michael Fong from IGLIP.
Dear Madam Sir, I heard digital dispute resolution, this terminology from a distinguished speaker. Also, I think technology-related dispute resolution needs a digital dispute resolution. About 2 days ago, 2 decades ago, 20 years ago, the ODR father, the chair of National Center for Technology Dispute Resolution, Ethan Catch, observed that the power of technology to resolve disputes is exceeded by the power of technology to generate disputes. To my understanding, if the traditional disputes resolution was applied, the justice would be delayed. Draft provisions for technology-related dispute resolution quoted an old proverb, justice delayed is justice denied. Digital dispute resolution can make technology-related dispute resolution fast, ODR fast. Digital dispute resolution can take a form of ODR, online dispute resolution. For example, I remind you of the report of Working Group 4 Electronic Commerce on the work of its 56th session held in New York in April 2018. With respect to section dispute resolution, the working group agreed to add a subsection on online dispute resolution, ODR. In the light of the relevance and the importance of ODR, to resolve of disputes arising from cloud computing transactions and take into account UNCITRAL's work in that area. If working group 4 electronic commerce can take into account UNCITRAL's work in that area, in working group 3, ODR. So why not we cannot take into account UNCITRAL's work in ODR area? Thank you. Later on, I will can use the example of zero knowledge proof. E-discovery software to illustrate how ODR or the neutral and third party to use information and the communication technology as the fourth party to resolve or prevent the dispute. I think time is limited. I want to address the issue right now. Thank you for your attention.
Thank you. I would like to give the floor to the delegate of Australia. Please, you have the floor.
Thank you, Chair. We simply raise our flag to say that we think that definitions about what technology is necessarily need to be broad because technology is evolving rapidly. And we can't be coming back every 5-10 years to redefine what technology is. I mean, artificial intelligence, geotargeting, automation, and other advancements in technology, information technology, specifically set the stage for more technological evolution. You know, I hold up my humble iPhone, which didn't exist 15 years ago. It exists now in various different forms. So, you know, so I think necessarily. The definition needs to be broad, and granted that maybe there might be some tweaks required here and there, but we would certainly support a broad definition. Thank you.
Thank you. Before I give the floor back to the authors of the draft provision 1, from the Secretariat's perspective, we also had the same understanding that this is, I mean, of course, the working groups, when they discuss text, the first thing that they want to discuss is the definitions. And then the next question that we don't get an answer because we would like to see what's going to be the rule that governs these definitions. And then we thought that the definition would be useful in the sense that if we go to the draft provisions, the working group would be asking what kind of disputes are we trying to address. So that is why the definition is provided here. On the questions about IP, we noted that IP is only one of the technologies that is being mentioned in the definitions. And of course, if we do embark on this topic, we would need to engage with the WIPO and others in there how to address IP disputes as well. We also thought that if it is the case that these provisions are provided and the parties now want to look at these model clauses and they want to see when they can use it, the definition in the draft provision 1 could give guidance to the parties on what kind of disputes could be, in which circumstances or in which kind of disputes they could utilize these model clauses. So we don't necessarily see it as a clause that needs to be included in the model clause, but possibly as guidance to the parties or guidance to the work that would be undertaken by the working group. Yes, and as Madam Secretary has mentioned, this was simply an attempt to conceptualize the work that is to be conducted by this working group when we mean technology-related disputes, technology disputes, or digital disputes. Before giving the floor back to the authors, we have a request from the delegate of the U.S., please.
Thank you to the Secretariat, and thanks again to those who have presented so far and giving us some food for thought. I'm going to play devil's advocate here and also perhaps pick up on the theme of the questions from the distinguished delegate of Switzerland and France, because I think there is a question of have we actually defined something that creates a contained universe or not? I suppose we could think of an established technology as a plow, for example. I mean, to be a bit extreme. While I think it's useful for us to have a definition, I wonder if in following in good form of a working group that we park that and see, because what we may find is that we develop rules that are more functional that might apply to other industries that have similar practices. But I realize I am playing devil's advocate so that we keep this issue in mind as we go forward. Thank you.
Thank you. As there is no other requests for the floor, Shai or Andres, would you like to respond to the questions and the comments made on the definition?
Yes, Jay, if I may. So first of all, thank you to the esteemed delegates and observers for their comments. We highly appreciate them. I would like, first of all, to address the issue of whether this is a too wide of a definition. I think that at the end of my remarks, I noted that this definition and these explanatory notes that we added to the definition were aimed, and as the esteemed delegate of Australia noted, were aimed to capture not only existing technologies, but technologies that will exist in the future. And therefore, to a certain extent, that requires us to use an open-ended, or I wouldn't say open-ended because we believe that it's not open-ended, but a more general definition rather than a very specific one. I do agree that at some point it may become blurry as to certain types of disputes, whether they are included in the definition or not. But I think as Andres mentioned in the beginning, and as the Secretary General noted, this is not a normative definition. It is not aimed to conclude which dispute the rules would apply to and which not. It's just a guideline for this group, for the working group, and for the parties in the future. So that is on those two issues. As to Israel's comments and whether we can try to kind of define or carve out things in order to specifically define disputes that have specific attributes, I think that is very, very difficult to achieve, A, at this moment, and B, if whether we can achieve it at all. Because as I explained during my explanation, and as is also highlighted in the explanatory notes, there are disputes that are in their core, in their essence, technology disputes, but are not presented as technology dispute. So that is one problem in addressing that issue. The second issue, that if we sometimes the requirement for speed stems from the identity of the party and their attributes. If it's an early stage startup, it will not survive a 6 months or 12 months or a 2-year arbitration or litigation. And therefore, it's not the special features of the dispute itself, but sometimes the special features of the parties that may require application of different set of rules to those disputes. These are generally the answers that I have. If Andres would like to add some comments of his own, then thank you.
Thank you, Shai. I think that for the sake of time, I simply want to underscore or to underline what was said by the Secretariat, by Jay, and what I mentioned at the beginning. These rules were conceived as opt-in rules. The parties will choose the rules, and the definition is it's aimed to provide guidance and scope. And in that sense, obviously, the definition may have a core that can be, work better, as Israel said. But I think the idea, and I think the definition provides that purpose, is to understand basically what we are talking about and what is, let's say, even undefine the contours of what we are speaking, but that is not intent to determine the applicability of the rules. And I think that is important in considering the way forward in the other rules, notwithstanding that can be put in a guideline or a note, and therefore can explain to the parties what is the purpose or what is the scope of which this rule are trying to cover.
Thank you. Unless there are other requests for the floor, we would like to proceed with the discussions on draft provision 3, which addresses case management conferences and when these case management conferences should be undertaken, especially with regard to technology-related disputes, and what is to be discussed during these case management conferences. On this provision, we have 3 speakers, Christian, Elizabeth, and Takashi, who would be kicking off the discussions and providing us a brief overview of Article Draft Provision 3. Christian, if you're ready to share your
Yes,
screen.
I'm ready.
Great, thank you.
You can hear me and see me. Distinguished representatives, I'm very honored to be allowed to present in the first place my colleagues and friends, Elizabeth Stong and Takashi Takashima, with whom I've drafted the provision. Elizabeth has been a federal bankruptcy judge in New York since 2003, and her prior experiences relevant to this project include 20 years as a business and commercial litigator, representing large businesses and financial firms in complex disputes. And she has been serving as a securities industry arbitrator for the Financial Industry Regulatory Authority and serving as mediator in a broad range of disputes. She has also trained judges in more than 25 countries on 5 continents, and she is a delegate to the UNCITRAL working groups 2, 5, and 6. Takashi Takashima is a senior attorney of the Ministry of Justice of Japan and serves as rapporteur for Working Group 2. His prior experiences relevant to this project include 12 years as a judge of various district courts in Japan, including the district courts of Tokyo and Osaka, and as a judge, he concluded over 1,000 civil cases and is highly experienced in case management. And yours truly is an independent arbitrator and advocate based in Vienna, professor of the Law University of Graz, and I'm a member of the Council of Arbitration of the Milan Chamber of Arbitration. And let me very briefly introduce this draft article number 3. We were mandated to consider the particular importance of case management for technology-related disputes. And to deal with this issue, in the first step, we exchanged the specimen procedural orders we were using for case management. And we held a video conference where we very quickly agreed that proactive case management is necessary, especially for disputes where time is of the essence, as other speakers noted. And we agreed that a special provision might be required. After the kick-off meeting, we relied in the first place on our own individual experience with case management, but we also sought inspiration in relevant rules and regulations where case management is already dealt with, such as in particular the UNCITRAL Notes on Organizing Arbitral Proceedings, the UNCITRAL Expedited Arbitration Rules, and ICSID's updated arbitration rules, as well as the ICC rules of arbitration. When drafting our own provision, The challenge was to balance flexibility on the one hand and predictability of the arbitral process on the other hand. Furthermore, our provision should not be overly prescriptive, but nevertheless provide meaningful guidance. In this vein, we identified 3 issues where we found that they needed to be settled in our opinion, leaving all other issues to the discretion of the tribunal. And those 3 issues are the timing of the case management conference and its mandatory or non-mandatory nature, the possible agenda of the case management conference, as well as organizational matters. And let me very quickly deal with these 3 issues. It goes without saying that case management is needed most at the beginning of any legal process, especially when the process is so complex as technology-related arbitrations. We quickly agreed that an initial case management conference was needed, but it was more difficult to establish whether or not we need to introduce a precise time limit, and if yes, what this time limit should be. Of course, case management must take place at the beginning, but on the other hand, it's only useful when the tribunal is sufficiently briefed about the specific features and background of the case. And to preserve the necessary flexibility to the greatest possible extent, we would propose to abstain from indicating a strict deadline, and we would propose a formula stating that the case management conference should take place, and I quote, as soon as possible after the constitution of the arbitral tribunal and before any oral hearing. The second characteristic feature of the initial case management conference which we propose is that it is mandatory. Now we realize that this would limit the discretion of the tribunal, but we believe that the advantages of initial case management outweigh this limitation. And furthermore, since the conference can be held by video conference, there should be no concern that the proceedings are unduly delayed. We would also propose that additional case management conferences can be organized in regular intervals or at any appropriate stage of the proceedings. This could be understood as a reference, for example, to regular case management conferences with an expert, to a mid-case case management conference, a pre-hearing case management conference, or also to a case management conference that is scheduled upon the request of a party. Again, our guideline is the flexibility of the process. Now, let me briefly come to the agenda. You will find that our draft contains a relatively detailed agenda for the initial case management conference. Now, in detail, the case management conference is the forum where practically every single procedural issue should be discussed. And it would seem impossible to establish an exhaustive list of all these matters. And we wanted to avoid that the rules become repetitive if every single issue is dealt with 2 times for the first time at the level of case management and then in the context of the provision that deals with the matter as such. But still, we want to provide meaningful guidance. And therefore, at the end of the day, we drafted a list of 9 issues. But this list should merely serve as an illustration, a reminder, a source of inspiration. It is not prescriptive. And it can also be used to introduce a certain issue at the case management conference, either by the arbitral tribunal or by one of the parties. You will also see, or you have seen, that we would propose to insert this list into the body of the provision, but this is, as all other issues, open to discussion, and this can also be put into an annex. And lastly, very briefly, let me deal with organizational matters. Again, all our organizational provisions are suggestions. They are not prescriptive. And the first and perhaps most important issue is that the case management conference can be organized by using, and I quote, any technological means as the tribunal considers appropriate, unquote. And this would obviously include telephone or video conferences or any equivalent that might be developed in the future, but it also covers the traditional in-person meeting. And we would also propose that the parties attend the case management conference when appropriate, not only with the legal representatives, but also with the internal technology experts who have presumably the best knowledge of the nature of the conflict. Then you will find that we also propose a provision that the tribunal is always allowed to ask questions, whereby it is obvious that these questions must be asked in accordance with due process, so that every participant has a chance to comment. And other than that, we deliberately abstained from dealing with any further organizational issues. It is left to the discretion of the tribunal whether the parties should receive a draft procedural order number 1 ahead of the case management conference, whether a verbatim is needed, or whether minutes should be drafted, issues of translation. This is all left to the discretion of the tribunal so as to preserve maximum flexibility. And with this being said, I give the floor to my colleagues and friends, Elizabeth and Takashi. Many thanks.
Christian, many thanks. Welcome to my chambers. This is Elizabeth Stong. I have unmuted myself, video and audio. Can you hear me?
Yes, we can. Please go on.
As we say, I see nodding. Distinguished representatives, colleagues, friends, it is a pleasure to be with you, even virtually, to consider these questions. From the perspective of a former litigator, a former arbitrator, and now a judge for nearly 20 years in the United States Bankruptcy Court, I strongly encourage the working group to consider favorably the opportunities presented by the topic of case management and dispute resolution, and specifically in technology-related disputes. I particularly encourage the working group to consider adopting both the mandatory component, as you have heard, including the recommendation that an initial case management conference be convened by the arbitration panel early in the proceedings, and as appropriate, that continued case management conferences be convened from time to time, and also a permissive component, as reflected in our proposal concerning topics to be addressed, modalities of attendance and participation, including, of course, the use of remote participation tools and the like. Christian has identified some of the benefits of this proposal that we focused on. These include developing an early and productive working relationship among the arbitrators, between the panel and the parties, and among the parties. In countless cases, though I should say I did count them ultimately, in many cases, as you will hear, I have seen the actual tangible benefits of this kind of engagement from the outset and throughout the case. It reduces and prevents the number of preliminary disputes that can arise in a highly contentious situation. And so often the path to the arbitration hearing or the court proceeding has been a very disputatious and contentious one. It puts the parties in a path to thinking about their situation in a productive and a problem-solving way about the dispute and about perhaps even their broader situation. And often in practical experience, and there needs to be a practical component to this, this kind of engagement can lead to a prompt limitation of the issues and even an early and consensual resolution. I need to emphasize that my observations are, of course, aspirational, and they may reflect a certain worldview, but they are also and absolutely deeply grounded in practical experience. As of today, we checked. I have presided in some 49,624 bankruptcy cases, and the number's probably gone up since this morning when we checked. These are the cases of businesses, large and small. These are the cases of natural persons. They include 772 Chapter 11 business reorganization cases where businesses were saved, jobs were preserved, and creditors were paid. I've also presided in some 1,739 adversary proceedings. These are lawsuits in the context of an insolvency or restructuring. And I can tell you, as a judge in an insolvency court, I'm constantly addressing situations where time and costs must be managed because there is never enough of either. They must be managed as effectively as possible. And the business that can successfully be reorganized in a period of a few months, you heard this same theme earlier in our afternoon session. The business that can be successfully reorganized in that period of time will likely fail. And the opportunities for recovery will be lost if the same process takes not just a few months, but months or even years. So I can tell you as well that I have seen in my work with judges around the world, and this is, as noted, 25 countries. It's been one of the most important parts of my life as a judge. These tools are productive in every legal system, not just a system such as the US common law system that assigns a certain role to the judge or perhaps in case management to an arbitrator. I've seen this in common law and civil law traditions, in arbitration, as well as court-based proceedings. Simply put, these principles have the capacity to cross borders, boundaries, disciplines, and languages. And we're better to think about that kind of thing, of course, than our working group. These circumstances have led me to appreciate the enormous benefits of early and intentional case management, facilitative case management. I welcome the opportunity to contribute to this effort in the working group, and thank you for your time. Over to Takashi.
Thank you, Elizabeth, for handing over. I am pleased to say a few words about our work in closing our presentation. Distinguished representatives and participants, allow me to begin by extending my support to what was presented by Christian and Elizabeth. I find it amazing that an independent arbitrator and two judges from different parts of the world worked together and came up with a common solution with relative ease. What enabled us to do so was the strong commitment we shared to provide parties to disputes with proper settlements, which could only happen when the determining third party had a good and clear understanding of what the case was about. In this sense, bearing in mind that an arbitrator will be tasked to solve tech-related disputes rapidly, but also with full appreciation of the complex technical issues, which were discussed by other speakers in the course of the discussions about definition, we see case management conference as an essential component of arbitral proceedings on tech-related disputes. As judge, I have handled quite a few disputes on development contracts of software and computer systems for enterprises. It was often the case that a decision as to whether a program or a system was in breach of a contract between the vendor and the user was at the core of the dispute. To focus the dispute to the issues most relevant, we agreed that it was not advisable to dwell, for instance, on the validity issue of the contract when the essential issue was of a technical nature. This brings me to point to paragraph 2D of the draft, which provides for the identification of contested and uncontested facts as a subject to be discussed at CMCs. I would also highlight that on the core technical issues, we have attempted to address them by providing that the arbitral tribunal should also discuss with the parties means to address technical issues pursuant to paragraph 2, subparagraph F, G, and H. Throughout, we have kept in mind the unique character of tech-related disputes and the needs of the users, and wish that our exercise will prompt further thinking by the working group experts. With this, we conclude our presentation on the CMC provision. Thank you.
Thank you, Takashi, for waking up very early in Tokyo. On this draft provisions from the Secretariat's perspective, I'll just draw the attention of the working group, which actually drafted the expedited arbitration rules, that the importance of consultations was also highlighted in the expedited arbitration rules context. But then in the expedited arbitration rules, we have a very short paragraph on the rules says that promptly after and within 15 days of its constitutions, the arbitrary tribunal should consult the parties. Most of what is to be discussed is contained in the explanatory note. Of course, we don't know how the work on technology-related dispute resolutions will evolve, but I think the intention of the authors was to highlight some of the items that need to be discussed during the case management conference in the provision itself, providing an illustrative list of issues that need to be discussed in this context. So with that, I would like to open the floor for any comments on draft provision 3. There were some issues that were highlighted by Christian and Elizabeth, whether a case management conference should be mandatory, on the timing, what are the elements to be discussed during the case management conferences, and the technological means to be used in employing case management conferences. So those were contained in draft provision 3, and we'd like to hear comments from the working group and the participants on the adequacy of draft provision 3. I would like to give the floor to Ms. Faye Wang on the platform.
Thank you, Chair and all. Looking beyond initial case management conferences in the draft provisions for technology-related dispute resolution, I would like to share my observation on these few days and my academic experience about case management concerning the enforcement of arbitral awards in London. As we all know, UNCITRAL technical notes on ODR provide a non-binding ODR procedural reference in both business-to-business and business-to-consumer disputes, in particular arising from cross-border low-value sales or service contracts concluded using electronic communications. With the increasing use of smart contracts and their digital assets in disputes, the enforcement of arbitral awards concerning disputed digital assets could be different compared with traditional transactions. There's a possibility that on a blockchain, all parties may remain anonymous. Arbitrators may implement decisions directly on-chain, and the arbitral award may be self-executed in an automatic dispute resolution process as being encouraged by the LawTech UK Jurisdiction Task Force in the Digital Dispute Resolution Rules published in April 2021, as presented by one of our earlier speakers, Mr. Lawrence Acker today. However, my concerns are about the technical power of an arbitrator as provided in the Digital Dispute Resolution Rules, in that an arbitrator can operate, modify, cite, or cancel any relevant digital asset if the arbitrator has been given, for example, the necessary private keys. And from a technological perspective, it would be worrying if an arbitrator could be given a party's private keys to manage digital assets. My question is that whether it is worthwhile that UNCITRAL technical notes on ODR, UNCITRAL expedited arbitration rules, or draft provision for technology-related dispute resolution could be looked into regarding the features of such special type of disputes concerning digital assets, and to provide necessary guidelines concerning the security and due process of arbitrators implementing decisions directly on-chain. Thank you.
Thank you. We take note of that comment. Of course, this is also something that can be discussed in the case management conferences, whether the arbitrator would have that technical power. But we would like to hear comments about any of the aspects of draft provision 3 on the use of case management conferences for resolving technology-related disputes. I don't see any hand. And also, to be the devil's advocate, I think the same question that the delegate from France and Switzerland mentioned is actually applicable in this sense as well, whether the provisions here actually applies to all types of disputes and not only technology-related disputes. Of course, there are some items in paragraph 2 which are more specific to technology, but the need to have the consultations quite early, to have them regularly, to use technological means, to the ability for the tribunal to ask questions to the parties may actually apply to all types of disputes and not only technology-related disputes. So we do note that, but we're wondering whether the illustrative items in paragraph 2 provide some guidance to the parties and the tribunal on what is to be discussed during the case management conference. Any other requests for the floor? We have Kenya.
Just following up on the comment that you have made in terms of the items which have been illustrated under draft provision 3.2, and in particular, sorry, Chairperson, I think I'm audible enough. In particular, under paragraph 3.2a on the nature of the technology-related issues presented in the dispute, Chair, this probably may also, if you recall the discussion that we were having under the definition of what constitutes technology-related dispute, in our view, it will be important for that definition to be able to guide on the unique elements which would qualify a matter to be technology, to be a technology-related matter. And we say so, Chairperson, because there is need for the arbitral tribunal during the case management conference to be guided on what are the elements which are so unique that they would define that matter to be technology-related. That would probably avoid a situation where there are so many matters that can be qualified as technology, and it would essentially remove any ambiguity as far as defining technology-related issues are concerned. Thank you, Chairperson.
Thank you. This also is related to the questions of providing more clarity on what we mean by technology and technology-related. Any other comments? Unless anybody in the working group or the participants or the experts who participated in the preparation of this provision or other provisions wants to take the floor, we would like to adjourn the session now. We'll just last call for requests for the floor. We have a request from France, please.
Merci beaucoup.
Thank you very much. It's not really a question, it's more a suggestion. With regard to technologies, I understand from what was said in my reading of the draft that there are two particularly important things here for the dispute as they relate to technology, speed and confidentiality. With regard to the first of these elements, speed, it's really a question that I would put to the members of the team that prepared this draft. Couldn't we meet this speed requirement with the adjudicator proposed by Switzerland? Imagine we have, well, I say Switzerland, but why not a Swiss adjudicator? The adjudicator as proposed by Switzerland, that we have a sped-up procedure that's been accepted, and a normal procedure. Wouldn't that be then a situation that would meet the needs of the corporations involved, or of the technology or the technique involved? So that's really in the form of a question.
Thank you. From the perspective of the Secretariat, until we have legal standards and adjudications, we would suggest the use of the expedited arbitration rules to save time. So that is one possibility. We have two requests on the floor from the platforms. We have China, and then followed by Kranguta. China, you have the floor.
Thank you, Jay. About the case management conference, I have two small questions. It's about the secretary of the tribunal. That is 3.2H. It says that the secretary should have a special technology or technical know-how or knowledges. Is this secretary supposed to manage the administrative staff, or someone who really understands technology? And also, maybe I have missed the discussion about the number of arbitrators. We believe the technical or technological disputes can be very complex. So, is it appropriate for us to stipulate only one arbitrator? That's all. Thank you.
Thank you. On the number of arbitrators, we'll be getting to that point tomorrow during session 7 when we discuss the neutrals and experts as well. We'll discuss the number of arbitrators at that point. On the platform, we have a request from Kranguta. Kranguta, you have the floor.
Thank you for this opportunity. I would only like to contribute to the idea that was brought into discussion by France, and actually the follow-up to the Swiss approach as to the value of adjudication. The value of adjudication is indeed undeniable. However, adjudication as a mechanism itself is of a fundamentally different nature than expedite arbitration. Because while in expedite arbitration, it is possible for an arbitrator to balance the decision with provisional measures that will ensure later on the reversal of such decision to the initial allocation of risk into the contract, adjudication is not of such nature. Adjudicator pronounce usually an interim decision which shifts the risk of insolvency, shifts the burden of financial nature during the remaining part of the duration of the contract. It unblocks the contract, but in the same time, fundamentally changes the allocation of risk, commercial risk, into the contract. For that reason, in the delicate balance of the technology-related disputes of certain types, like, for instance, research and development disputes, or other disputes in which both parties are cooperating towards a desired technical goal, in which the risk is a very sensitive one, because the intellectual property rights which are developed under this type of contract at the end are to be valued according with the market that they will reach and how that market is predictable or not, it's a matter of a certain risk. So my only point here is that we have to look at adjudication as one option, which may be only valid as long as parties are 100% conscious about the risks being shifted as a result of the adjudicator decision and how this is impacting the achievement of the contractual goal. Thank you.
Thank you, Kranguta. Christian, do you have a response to the delegate of China?
Yeah, to the distinguished representative of China, just as a matter of clarification, I would like to state that this secretary of the tribunal is is meant to be a pure administrative secretary and not a kind of additional expert. But if we have a technology-related arbitration, the parties rightly expect that the arbitration as such in terms of technology lives up to the standards of the parties themselves, who are usually very experienced, and would expect that in terms of video conferencing, in terms of working with platforms, of transmission of voluminous documents, etc., there are no issues at all. And I think here a technology experienced administrative secretary could be very helpful. Thank you.
Thank you, Christian. During the deliberations of these provisions, I think one thing that came up is that all those involved in the dispute resolution process of technology-related disputes, not only the arbitrators, but the neutrals, experts, parties, the counsels, and their knowledge of technology was highlighted, that those would be essential in resolving the disputes in a very quick, efficient manner. And I think that was what was trying to be captured in paragraph 2, subparagraph H. Unless we have other requests for the floor, we would like to adjourn the session for today. We're ending a bit early, but please be back with us tomorrow at 11 o'clock to continue our discussions. Just so that you have an idea of what we'll be discussing tomorrow, we'll be first discussing the timeframes to be provided for technology-related disputes, also for rendering awards, which will be draft provision 4 and 9. And then we'll be talking about the number of arbitrators as well as the appointment of neutrals and experts in the second hour. In the afternoon, we would like to touch upon the draft provisions on confidentiality and on evidence, each taking 1 hour for the afternoon sessions. So that is the plan for our discussions tomorrow. So please be prepared to make your comments on the draft provisions, as I mentioned, during the interventions tomorrow. So with that, I would like to close the sessions, and thank you, Merit. Thank you very much for taking part in today's discussion. Thank you very much.